Senate Judiciary is now in session. We're going to hear SB 255, and the Honorable Senator and my friend Sharon Carson is going to present the bill.
Thank you very much, Mr. Chairman, and good afternoon, members of the Senate Judiciary Committee. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon Senate Bill 255 FN, and I would just like to add that I do have an amendment to Senate Bill 255, which is amendment number 2023-0498S. Mr. Chair, this bill seeks to create a new chapter detailing consumer expectation of privacy. As you know, Mr. Chair, we passed a constitutional amendment a few years ago, really emphasizing that our citizens have the right of privacy. And people today produce 25 times the online data that they did in 2010, recording just about every aspect of their lives. But New Hampshire citizens today have no rights to control their personal data, and businesses have no obligation to steward the data that they hold or respect the wishes of consumers when they ask that their personal information not be distributed or who want to delete it. Senate Bill 255 will establish the right of consumers to protect their data and the responsibility of businesses they deal with to respect their customers' privacy wishes. The bill grants all of us consumers the right to access, correct, delete, and obtain a copy of personal data, and gives us the rights to opt out of the processing of our personal data for certain purposes. It also establishes a framework for controlling and processing personal data and establishes responsibilities and privacy protection standards for the various businesses that control and or process our personal data. Senate Bill 255 is modeled after legislation that has passed in the states of Virginia, Colorado, and Connecticut. This model has been evaluated and worked on by many of the same stakeholders and industries that do business here in New Hampshire. This bill is also comprehensive. It covers a lot of material, which is the result of years of work and discussions, all of which is necessary to provide rights for consumers while minimizing disruption to commerce. It has a thorough definition section, clearly establishes consumer rights, create obligations on the part of the controllers, who are those who have the relationship with the consumer, and obligations for processors or those who process data on behalf of the controllers. It is time the state of New Hampshire acts to provide rights to consumers to control their personal data held by businesses, and our legislation is a meaningful first step in establishing those rights. Thank you very much, Mr. Chair. I will stop my testimony at this point and thank everyone. I appreciate you listening, and I will ask you to hold your questions for me. There are folks from the industry here that will be able to answer your questions.
Thank you, Senator Carson.
Thank you, Mr. Chair.
Ryan Harkins.
Good afternoon. Thank you, Madam Chair and Mr. Vice Chair. My name is Ryan Harkins. I'm Senior Director of Public Policy with Microsoft, and I'd like to thank you for the opportunity to be here today. We support Senate Bill 255. We think that it would provide important new privacy protections for New Hampshire consumers while enabling industry to continue to use data in responsible and innovative ways. We at Microsoft have been calling for comprehensive privacy legislation in the United States since 2005. And the reason is that we could see, even back then, growing distrust in the public towards technology and towards our industry. Those concerns have only grown over the course of the last 2 decades. And in our view, the only way to start earning that trust back is to pass new laws. laws that will provide real and credible privacy protections to individuals while requiring businesses to be responsible stewards of the data they collect. And here in the US, we have traditionally taken a much different approach to regulating privacy than some of our friends around the world. So whereas in the European Union, for example, they have long had a comprehensive privacy law in place that addresses all privacy issues across all industries. Here in the United States, we have traditionally taken a sectoral approach. So we've had narrow privacy laws that address, say, privacy in healthcare, like HIPAA and the HITECH Act. Or we have something called COPPA, the Children's Online Privacy Protection Act, which addresses the privacy of kids online. It has become apparent that that sort of patchwork approach no longer works. And thankfully, although Congress has been unable to get a comprehensive privacy law over the finish line, states have begun to act. We have now seen 5 states pass comprehensive privacy laws since 2018, and we have been working across the states to try and support efforts in state capitals to pass comprehensive privacy laws. In our view, any comprehensive privacy law has to contain several elements in order to provide consumers with real and credible privacy protections. The first is that any privacy law has to apply to modern online data sets. That means data that is not just identified or data that is stored in association with your name or your mailing address, but identifiable data. Data that is stored with, say, a cookie ID or an IP address or a device identifier. Those are the kinds of data sets that are used to track and target consumers online today. And therefore, in order to provide people with real protections, any privacy bill, any privacy law has to apply to modern online data sets. And SB 255 does a good job of doing that. It defines personal data as any information linked or reasonably linkable to identified or identifiable natural persons, meaning individuals who can be identified directly or indirectly. And this is consistent with the approach we've seen taken in Virginia, Connecticut, and Colorado. It also provides for a sufficiently robust definition of de-identified data. De-identified data is exempted from the bill, and therefore, in order for data to be considered de-identified, it should have to meet a truly rigorous standard. And SB 255's definition does that because it refers to data that cannot reasonably be used to infer information about or otherwise be linked to an individual or a device. So, modern online data sets. The second thing that we think needs to be part of any credible privacy law is it has to provide people with the rights that are necessary to empower them to control their data. And SB 255 does a good job of that. It would provide people not only with the rights to access your personal data, the right to correct inaccuracies in your personal data, the right to delete personal data, the right to port your personal data, meaning to take your personal data from, say, Microsoft, if you're tired of doing business with us, and take it to a different company. But it also would provide consumers with the right to opt out of certain sensitive processing activities, namely data sales, processing of your personal data for targeted advertising, and the profiling of consumers for certain consequential decisions, like providing you with insurance, credit, housing, etc. We also like the fact that the bill, similar to the law in Connecticut, would require companies eventually to comply with opt-out requests that are made by virtue of an opt-out preference signal. You can think of this like an easy button. Perhaps in your web browser or in your operating system, this would be a place where consumers can go and at one place and one time press a button and opt out of being tracked and targeted, consistent with the opt-out right, from all websites they may visit. And it is a way of allowing and enabling consumers to exercise their right more effectively. So rather than requiring them to go to hundreds of or thousands of different websites and opt out individually, they can do so at one place and at one time. We also like the fact that this bill would require opt-in consent in order to collect and use and share sensitive information. So information like geolocation information or biometrics or things like race, ethnicity, or religious beliefs. Third, we think any privacy bill needs to impose affirmative obligations on companies to be responsible stewards of the data they collect. So these are obligations that would apply irrespective of whether a consumer exercises rights. And we think SB 255, consistent with the other state laws that have passed, does a good job of doing that. It would impose data minimization requirements, meaning you should only collect and retain the minimum amount of data necessary for a specified purpose. It would require companies to adopt reasonable security safeguards to protect information. It would prohibit companies from engaging in unlawful discrimination in the way they collect and use and share data. And it also does a good job consistent with global data protection laws like the European Union's General Data Protection Regulation, or GDPR, consistent with the privacy laws that have passed here in the United States. It does a good job of imposing different but complementary obligations on different entities based upon the role they play in the online ecosystem. So the primary obligations in the bill apply to controllers. These are entities that, according to the bill language, they determine the purposes and means of processing data, meaning they're calling the shots about what's being collected with data and why. They typically are the organizations that have relationships directly with consumers. It imposes complementary obligations on service providers or processors, meaning those are entities that may provide back-end processing services to controllers. And so their responsibilities are to enable the controllers to comply with their obligations under the law. Finally, we've made some suggestions that I understand are being incorporated in the amendment in order to strengthen the bill just a little bit and tighten things up from a consumer protection standpoint. And otherwise, I would like to thank you again for the opportunity to be here and thank you for your leadership in attempting to advance this bill. We would like to be a resource and attempt to be helpful to you in any way that we can. And with that, I'd be happy to try to answer any questions.
Thank you very much for your testimony this afternoon, Mr. Harkins. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Any comment? Really clear. Understood everything. Quality whole testimony. Thank you.
Thank you.
Next, we're going to call Brandon Garrod.
Good afternoon, Madam Chairperson, Mr. Vice Chairperson, members of the committee. Thank you for taking the time to hear my testimony today on SB 255. For those of you that don't know me, my name is Brandon Garrod. I'm a Senior Assistant Attorney General at the New Hampshire Attorney General's Office. I'm also the Chief of the Consumer Protection and Antitrust Bureau that would be primarily and exclusively responsible for the enforcement of this bill if it were to become law in the state of New Hampshire. I come today to testify neither in support nor against this bill, but simply to provide information about the Attorney General's Office's high-level reactions to this proposed additional responsibility that would be attributed to the Consumer Protection and Antitrust Bureau if it were passed. First off, I would just like to say that the subject matter of this bill and the intent of this bill, what it is trying to do to give consumers the power to control their personal data, who uses it and what they use it for, is certainly something that the Attorney General's Office is in full support of. Consumer privacy in their own data is really the future of consumer protection, as I see it. It's how we're advertised to. It is, every keystroke we put into the internet contributes to profiles that are then used by companies to sell us things, to direct us on the internet. And the ability for consumers to control who uses that information and give power to consumers to control and make adjustments based on their own expectations and their own wishes about their own personal information, certainly something that is in line with consumer protection generally and with the goals of the Attorney General's office. I also want to take a moment to express my appreciation for the comprehensiveness of this bill, because oftentimes I'm sure every legislative session there's a number of bills that seek to attribute additional responsibilities to the Attorney General's office. Oftentimes they will simply make something unlawful and then leave it up to us to figure out the nuts and bolts of it. And this is really thought through and comprehensive and provides I believe adequate definitions in most areas, as well as a framework that under the right circumstances could be enforced and could make a meaningful difference. But there are some hurdles to that, which I'd like to talk to you about today. And so I am confident in saying that, as the chief of the Consumer Protection and Antitrust Bureau, if this bill were passed into law today, given the current makeup of the Consumer Protection and Antitrust Bureau and the other responsibilities that are assigned to the Consumer Protection and Antitrust Bureau, this would be an extremely difficult, if not impossible, bill for us to enforce from a purely resource perspective. The Consumer Protection and Antitrust Bureau is responsible for a number of things at the Attorney General's office. The most prominent of which is the review and response, investigation and prosecution of consumer complaints that come into the Bureau, and we receive thousands of them every year. I review all of those complaints personally. I assign the complaints that allege, unfair, deceptive acts or practices, whether it be an unfair, deceptive act or practice as contained in 358A, or something else that has been defined as an unfair, deceptive act or practice, like this would be, that exists otherwhere in New Hampshire law that's also attributed to the Attorney General's office. That includes any unfair, deceptive acts or practices that are not regulated by the Insurance Commission, the Banking Commission, or the Bureaus of Securities Regulation. It includes, the regulation, registration, and overview of all of New Hampshire's health clubs, all of New Hampshire's martial arts studios, the registration, review, and approval of all condominiums in New Hampshire, all subdivisions in New Hampshire, and the review, investigation, prosecution of elder abuse and financial exploitation, the review, investigation, prosecution of complex financial fraud, securities fraud, white-collar crime, and then the antitrust side of the Bureau, which is essentially staffed by the same folks that do the consumer protection. It's a hybrid approach. And so our antitrust side is assigned with reviewing, investigating, and responding to all proposed mergers in the state. Recently, there's been a number of prominently public healthcare mergers, consolidation in the healthcare industry that has kept our antitrust bureau straight out just looking at healthcare mergers. And has had those folks limited in their ability to contribute to the other work of the Bureau. And that's just, a really high-level snapshot of all of the work that the Bureau is currently responsible for. So to write a new chapter, and that's exactly what this does, an entirely new chapter that adds on to the responsibilities of the Consumer Protection and Antitrust Bureau and require complex understanding, investigation, enforcement, prosecution. I do not believe it could be effectively done with the resources that we currently have. I think it could be done with additional resources, but I think we want to be a Department of Justice that is able to respond to the tasks that are assigned to us by the legislature. We don't want to ever be in a position to have somebody filing complaints with us and have to say to them, due to limited resources, this just isn't something that we have the ability to take on. So I'm here to inform the legislature that if this were to go forward in its current form and become the responsibility of the AG's office, it would require additional resources, likely in the form of multiple additional attorneys, support staff, and at least one more investigator in order to meaningfully perform all the tasks that are assigned to us in this very comprehensive legislation. Another limitation that we have in the way that's currently structured is simply a matter of technical expertise. We have minimal experience in the world of, actually the nitty-gritty work of data privacy because, as was testified to previously, up until now, New Hampshire has no oversight over consumer data. There is no law that places requirements on folks like us to review the potential use or misuse of data. So we simply don't have that expertise. We could certainly become educated. We could certainly hire folks that have that expertise, but that would, again, require additional resources for us to do so. That being said, purely on the resources and the expertise side of things, there are a number of other concerns that I have with some of the language of this bill as it currently exists that I just wanted to point out from an enforceability perspective. And so the first one that I will point you to is on page 8 as introduced. It would be 507H6, which is controller responsibilities. And this is the first, and as I see it, the responsibility of the controller that would likely generate the most consumer complaints for our Bureau. Controllers of data would have to limit the collection of personal data to what is adequate, relevant, and reasonably necessary in relation to the purposes for which such data is processed and disclosed to the consumer. I certainly understand and take no issue with the intention of what this is trying to do, but from an enforceability perspective, for us to determine in any given industry what is adequate, relevant, and reasonably necessary, it's a tall task, and I think is a really too much of a objective standard for us to really, I mean, the way this would work is we would get a complaint from somebody that says, hey, company A is collecting data that, is way in excess of what is adequate, relevant, and reasonably necessary. In order for us to investigate that and determine whether or not the law is actually being violated, there needs to be a clearer standard for us to understand where that line is. And I think given the broadness of those terms that's used to define where the limits are on their ability to collect, we would have difficulty investigating and reaching a definite conclusion that would give us confidence to be able to go into court and say, yes, this company is collecting data which far exceeds what is adequate, relevant, and reasonably necessary. There could certainly be instances where it's a clear-cut case. I mean, if it's, let's say a cable company and they're collecting data about, somebody's, I actually can't even come up with a hypothetical, but, I think you know where I'm going. There would be cases where you can look at it and say, this is what they say they're doing, and they're collecting this piece of data, and that is clearly defies logic, and there's no reason they would need that. Those cases would be somewhat clear-cut, but I think that the majority of the cases would be a much closer call. So I would suggest that we consider, if the legislature moves forward with this, finding a way to make it more clear as to where the line is, what the limit is on what amount of personal data controllers can collect and manage without violating this law. The next piece I'd like to point out is on page 9. It's Roman numeral 3 of the same section. It reads that a controller shall provide consumers with a reasonably accessible, clear, and meaningful privacy notice that includes, and then it gives a number of standards. This, as a requirement that needs to be enforced standalone, I don't think there's any issues with it, but I could see it playing out in a way where if a consumer finds out that a company is using their data and has not received notice, and we went to bring an enforcement action, the company's defense could be, well, this statute does not specifically say at what point in time we're required to issue that notice to the consumer. So if the intent is that prior to a company using a consumer's data, they are required to issue this notice, I would encourage the legislature to consider adding language that makes it really clear at what point a company that's using somebody's data is responsible for sending out that notification to consumers. That would give us a much more clear, enforceable standard that we could use to determine whether folks are or are not violating this law. The final pieces that I'd just like to bring to your attention, one goes back to the original issue of resources and just sort of amplifies it. The legislature has specifically decided that, I'm sorry, I'm on page 16 of this bill as introduced, looking at Roman numeral 4. Nothing in this chapter shall be construed as providing the basis for or be subject to a private right of action for violations under this chapter. 358A anticipates a sharing of the responsibility of enforcing the Consumer Protection Act between the Attorney General's office and the citizens the consumers, the folks whose rights are being violated. So unless you have a statute like this, which specifically takes away a private right of action, the majority of cases under 358A, if the Attorney General's office doesn't have the resources to get to it, if the Attorney General's office chooses not to bring an action for any number of reasons, consumers have the ability to go into court and to advocate for their own rights, bring a private right of action if they believe the Attorney General's office is wrong, or if they believe that the Attorney General's office should have brought something on their behalf. By taking away that right for private, I'm sure there are reasons for doing so, but by doing so, it places the enforcement of this statute 100% squarely on the Attorney General's office, which even more so amplifies the concerns about the resources that would be required to enforce this. This would not be a case where we'd be able to tell a consumer if we were at maximum capacity, couldn't take on a case, hey, you have a private right of action, you can explore your own legal remedies in this case. They don't have the ability to do this. It would be us or nothing. And then finally, I'd just like to point out what I see as an inconsistency on the same page, page 16, and I'm looking at Roman numerals 2 and Roman numeral 3, which deal with the Attorney General's issuance of notice prior to bringing an action if there's a potential violation of this chapter. So Roman numeral 2 anticipates that the Attorney General shall, prior to initiating any action for a violation under this chapter, issue a notice of violation to the controller if we determine that a cure is possible. So under 2, it requires us that before we bring any action, we have to determine whether a cure is possible, and that is the standard for which it determines whether we have to give notice or not. But then in the subsequent section, section 3, it gives a number of factors in determining whether to grant a controller or processor the opportunity to cure an alleged violation. There's a number of factors that we can consider, but these factors don't seem to be in line with the prior section, which really deals exclusively with whether or not it can be cured. So for example, the factors that we can consider under 3 when deciding whether or not we need to issue a notice prior to enforcement: the number of violations, size and complexity, nature and extent of the controller or processor's processing activities, substantial likelihood of injury to the public. If the only factor that we can consider in determining whether we need to issue a notice of intent to cure is whether it's curable, this raises an inconsistency, and I would look at this and I would say, well, it seems like we could also decide not to give an opportunity to cure, even if we thought it was curable, based on the number of prior violations or the substantial likelihood of injury to the public. So anytime you have an ambiguity like that, we want to make sure that we're really certain of what our obligations are under a statute, because if we brought an action without giving an opportunity to cure and there was a credible argument that could be raised, embedded in this, our action could potentially be dismissed for failure to provide proper notice. So I just wanted to point that, what I perceive as an inconsistency, out to the committee, and I have been talking for a very long time now, so I would be happy to take any questions that any members of the committee might have.
Thank you for your testimony. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question. If there were to be a change or an amendment to this Senate Bill 255 as written to allow a private right of action, should there be any type of notice requirement to the Attorney General's office that the complaint's being filed or the claim's being pursued?
Yes, I would say yes, because it would be consistent with the current notice requirement under 358A. So currently the way it works is anytime somebody files a private right of action under 358A, they're actually required statutorily to give us notice of that action. We use that information. I review every single one of those, and they really enhance our enforcement priorities to have a pulse of the community for what private citizens are doing. If we get one complaint against a business, for example, we look at it and we say, yeah, it could be true, could not be true, but then we see that 3 other consumers have filed private rights of action. that highlights for us, while this business might be a problem, even though we don't have the complaints that we would expect to see if it was really a problem. So it's really important, I think, for us to be able to evaluate what's going on in the community in order to inform our own enforcement priorities and make sure that we're not missing anything.
Thank you.
Are there any further questions? Senator Whitley?
Thank you, Madam Chair. Thanks for taking my question. So I'm just looking down to the fiscal note and not seeing anything from the Attorney General's office and wondering if you're working on an amended fiscal note to reflect what you said at the top about what resources would be necessary should this bill pass.
So I was surprised to see this too. We are, we respond, at least we try to respond to every request for a fiscal note that we get. And usually anything that has to do with consumer protection initially comes in and then is assigned to me. It says clearly here that the Department of Justice was contacted, but it appears that perhaps we did not do a fiscal note. So to the extent that would be helpful, and to the extent that happened and we missed it, I apologize, and I would be happy to submit a fiscal note at this point to reflect the testimony that I provided earlier.
Thank you. Are there any further questions? Seeing none, thank you very much for your
Thank you.
testimony. Gabrielle, could you check to see if anyone else has signed in the back? Okay, next we're going to call Andrew Kingman. Good afternoon, Mr. Kingman.
Hi, good afternoon, Madam Chair and Mr. Vice Chair. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a coalition of over 30 companies and 6 trade associations. We span a broad variety of sectors from retail, telecom, technology, automobile, payment card companies. My background is in privacy compliance as well, so actually helping clients navigate different privacy laws throughout the country. I have been part of the Connecticut Privacy Task Force, the Oregon Attorney General's Task Force on Privacy. So this is something that we're working on across the country. We wanted to start by saying we very much appreciate Chair Carson's putting forward of SB 255. While we do have some amendments that are contained in our written testimony, we broadly believe that this is a sensible approach to privacy at a state level. It does a very fair job of providing consumers increased control over their personal data and providing them some core rights to exercise, imposing obligations on businesses to document, understand the risks and the benefits that particular types of data use and data processing present to consumers, and to mitigate those risks, and requires obtaining consent in order to process sensitive data. So overall, while we do have some amendments that I'm happy to speak to in questions or are contained in our testimony here, our written testimony. A couple of them have been taken care of already in the existing amendment, including the effective date and the targeted advertising fix. I'd like to take an opportunity to review with my members the additional amendments that have been offered. But, broadly speaking, again, we think this is a fair and balanced approach, and appreciate the chair's willingness to move this forward here.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much. The chair will call Chris Gilrain. Did I get that correct?
You absolutely did.
Oh, great.
Thank you, Madam Chair, Mr. Vice Chair, members of the committee. Appreciate the opportunity to be here to chat with you about SB 255. TechNet is a industry association made up of over 100 of the most innovative companies in the country. We have members in all different niches of technology, from what you would consider kind of your traditional hardware, software, search, social media, into things like autonomous vehicles, electric vehicles, advanced energy companies, fintech, all kinds of things. The thing that kind of unites all of these companies and gets their attention is data privacy. It's kind of the umbrella that covers all of these companies because we all rely on data. Overwhelmingly, TechNet's members support a federal data privacy standard, and we have been working hard on that front. Our federal team is leading a inter-agency, inter-industry push for a data privacy bill. In the absence of a unified standard that covers all Americans, interoperability with existing models is paramount to us. And on that front, we greatly appreciate the legislation put forward by the chair. It aligns very significantly with existing models in Colorado, Connecticut, and elsewhere. The other benefit, in addition to the strong protections, rights, and responsibilities that the bill that other speakers have already covered, is transparency. Those rights and responsibilities are clearly and concisely laid out in statute. It is not subject to an opaque rulemaking proceeding or kicked to the courts to litigate. So to the extent that this is a regime that is operational, we really appreciate the chair's work on that. Now I'm going to say something that might sound contradictory to our love of interoperability. However, if you will indulge me, the global privacy control language at this point, both Colorado and Connecticut have a delayed implementation on the global privacy signal. Those will be, while the bills, the laws themselves will be in effect in July of this year, the global privacy or the global opt-out provisions are going to be delayed while a rulemaking proceeding takes place in Colorado. A similar proceeding will not be taking place in Connecticut. They'll just implement that portion after Colorado finishes its proceeding. We have a feeling, based on what we've seen, it's difficult to see how this will be operationalized. I've included a couple of open questions there in my written testimony in terms of how something like this, for example, interacts with a VPN or how it works on mobile. There are just some open questions as to how this is going to be implemented, and I assume that through this Colorado rulemaking proceeding, we might uncover things that should be built into the law. I do appreciate that SB 255 includes the same guardrails that are in Connecticut in terms of self-dealing and other statutory guidelines as to how these things are going to work. I just think that more data is going to come out in terms of how this will be operationalized. And to the extent that we could perhaps wait and see how this works out in Colorado and see if there's additional statutory language that's going to need to be baked into this as opposed to just including it in the legislation with a delayed implementation date. But overall, tremendously supportive of the concept and the interoperability, and I want to offer TechNet's resources here. I am very lucky to work with 100 companies with very smart people who get me feedback pretty efficiently. So if there, to the extent that there are any questions or comments from the panel, I'd like to be a resource. So appreciate your time.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
The chair will call Henry Vayu.
Thank you, Madam Chair and members of the committee. For the record, my name is Henry Vayu, and I'm here on behalf of CTIA. CTIA is the trade association of the wireless industry, and CTIA strongly supports consumer protection and the ability for consumers to protect their data. Privacy laws are largely a national and international issue, and that's why we think it's appropriate for the federal government to address it. But having said that, we recognize that inaction on the federal level creates a vacuum, and that's why states are going forward and enacting their own bills. And we understand that this bill is largely modeled after Connecticut. And we would be happy, received the amendment today. I'll pass that on to the CTIA folks. I know they had a couple of tweaks here and there, but we would be happy to work with the sponsor and the other advocates for the bill. And that concludes my remarks.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much, Mr. Vayu. Next, we'll have Rick Fabrizio. Good afternoon, Mr. Fabrizio.
Madam Chair and members of the committee, thank you for letting me speak today. I'm Rick Fabrizio, Director of Communications and Public Policy for the Business and Industry Association, New Hampshire Statewide Chamber of Commerce. BIA supports SB 255, which would provide reasonable protections for businesses and consumers through a comprehensive data privacy law. Our members generally prefer to see such legislation enacted at the federal level, but in absence of that, we are supportive of New Hampshire joining other states acting in absence of that action. SB 255 was crafted with industry input, which helps assure a practical regulation of commerce. It's also sound legislation because it's closely modeled on legislation passed in other states, including the Connecticut law, which was passed last year. Modeling it on existing state legislation helps reduce the impact of a patchwork of state laws, again, in the absence of federal regulation. BIA and our members, however, would like to see industry-supported improvements in the bill. They are in particular related to exemption of small businesses, as seen in the Connecticut Data Privacy Act and Virginia Act, which took effect last month. Both essentially limit applicability to businesses with at least 100,000 consumers. SB 255's language should also more clearly and consistently state the definition of a child, while the bill's language states child has the same meaning as provided in the Children's Online Privacy Protection Act, COPA. It later uses the term known child, which raises concern about unintended liability. Lastly, the bill's proposed effective date of January 1st, 2024 will leave businesses with only about 7 months to ensure appropriate compliance. An effective date of January 1st, 2025 would allow more time for businesses to get protocols in place. I'll be happy to address any questions the committee may have.
Thank you very much for your testimony. Are there any questions from the committee? Just so you know, Mr. Fabrizio, the amendment that was also introduced, it did change the effective date to January 1st, 2025.
Excellent. Thank you.
Okay, are there any questions? Okay, seeing none, thank you very much. Are there any other members of the public that would like to speak to Senate Bill 255? Okay, seeing none, we're going to go ahead and close the public hearing. Thank you very much for your attendance today. We have concluded our work. It's kind of like anticlimactic.